Good afternoon, everybody. Um, this is Amy, and welcome to my channel, Case by Case. It's a brand new channel, and I'm just getting started and just learning all the ins and outs of the YouTube thing here. So bear with me. And I wanted to take some time out today to discuss some documents that I don't believe have been circulated out there that I feel uh, might be interesting for some of you who have been following the Ray Hanish case and the slow going process of getting justice for him. As you guys should know by now, if you follow the case, Ray Hanish was murdered back in March of 2019, approximately around March 13th. Garrett Kenneth Kurtz has been charged in that murder, and Garrett is currently waiting trial in the White County Jail. He's been in the White County Jail now for about 2 months, uh, attempting to pursue a plea deal that I believe I can confirm at this time through sources is not going to happen, or it has not happened at this time. And he will be sent back to the Pendleton prison this coming Tuesday. So with that being said, I'm going to attempt to share my screen and go over some of these documents that I have that might be of interest to some of you in regards to the case and what's been transpiring. That's my co-host in the background, Mr. Rorak, my African gray parrot who likes to chime in whenever he knows something important is being done. He wants to make himself known. So if you hear that noise, I apologize because it's just not stoppable. These are some of the court documents. I hope you can see these as I'm sharing my screen. The original count 1 of the charging information for murder was filed back on February 28th of 2023. And I will read those now. The count 1 is stated within the document: the prosecuting attorney for the 39th Judicial Circuit of the state of Indiana, upon oath or affirmation, states that between March 13th, 2019 and March 17th, 2019 in White County, state of Indiana, Garrett K. Kurtz did knowingly or intentionally kill another human being, to wit, Charles R. Hanish, all of which is contrary to the form of the statutes in such case made and provided against the peace and dignity of the state of Indiana. Signed, Mark A. Delgado, prosecuting attorney for the 39th Judicial Circuit. As you can see here in this charging affidavit, there's a list of state's witnesses. I believe these are the witnesses that were called to share testimony in front of the grand jury, which is the jury that indicted Garrett. And I thought it was very interesting on this list who is the first witness that was called in to testify: Mrs. Talitha Beckley. As my next live the next lives that I'll be doing, we'll be discussing her in depth and going over her interrogation video in the Nicole Bowen murder. But I find it very interesting that she is on the state's witness list that was for the grand jury. So next, also filed on February 28th of 2023 in the White County Circuit Court, is count 2, the charging information for auto theft, which, for those of you who do not know, Garrett Kurt was arrested in Tippecanoe County while driving Ray Hanish's vehicle. I will be discussing that later on as well. But in count 2, the charges state the prosecuting attorney for the 39th Judicial Circuit of the state of Indiana, upon oath or affirmation, states that between March 13th, 2019 and March 17th, 2019 in White County, state of Indiana, Garrett K. Kurtz did knowingly or intentionally exert unauthorized control over a 2008 blue Pontiac G6, the motor vehicle of Charles R. Hanish. with the intent to deprive Charles R. Hanish of the vehicle's value or use, all of which is contrary to the form of the statutes in such cases made and provided and against the peace and dignity of the state of Indiana. Signed, Prosecuting Attorney Mark A. Delgado. Again, state's witness list is the same. Third, in count 3, charging information for theft, which is a class misdemeanor. The count 2, if I scroll back up here, you'll see auto theft was a level 6 felony. And of course, the murder is felony. So in count 3, what it states is that between March 13th, 2019 and March 17th, 2019 in White County, state of Indiana, Garrett K. Kurtz did knowingly or intentionally exert unauthorized control over the property of Charles R. Hanish, to wit, a Vizio 50-inch LCD smart TV, with the intent to deprive Charles R. Hanish of any part of the use or value of the property, all of which is contrary to the form of the statutes in such cases made and provided and against the peace and dignity of the state of Indiana. I really hope he's not that annoying to everybody listening. He's so loud and it's so high pitched. Yes, you. Thanks. This is the indictment for the auto theft, the Class A misdemeanor. The grand jury of the County of White duly and legally impaneled upon their oath to affirmation, do present that there is sufficient cause to determine on or about March 13th, 2019 in White County, state of Indiana, Garrett K. Kurtz did knowingly or intentionally exert unauthorized control over the property of Charles A. Hanish, to wit, the 50-inch Vizio 4K smart TV, with the intent to deprive Charles R. Hanish. So that is just confirming that the grand jury did indict him, and that was subscribed and sworn on the 23rd day of February. We also have those for the indictment of the vehicle, which reads the same as the count 2 charge. And also we have the indictment here for the murder, class felony for murder. The grand jury of County of White, duly and legally impaneled upon their oath or affirmation, do present that there is sufficient cause to determine on or about March 13th, 2019 in White County, state of Indiana, Garrett K. Kurtz did knowingly or intentionally kill another human being, Charles R. Hanish. Based on the arrest report from when Garrett and Nicole were pulled over in Ray's vehicle in Tippecanoe County, that arrest was made on the 14th of March. So I believe that it's fairly easy to speculate that at that point in time, Ray was no longer with us. So I believe March 13th is very accurate as far as the date that this murder was committed. We're going to get into a timeline of some of these events a little bit later in my lives as I pursue the covering of the Ashley Garth case. This right here this is the court duly advises now that probable cause exists for the filing of said charging information. This was the summons to the defendant ordering the defendant to appear in this court on the 3rd day of April 2023 at 9:45 a.m. This was when they actually approved that the defendant may appear in court via Zoom, and the court will coordinate defendant's Zoom appearance. Now, we're going to get into some of the filing that was done by the state in the verified petition requesting the appointment of a special prosecutor. This is filed, I believe, by the defendant, Garrett K. Kurtz, by his counsel, Cody L. Spear, the law offices of Cody Spear, requesting the appointment of a special prosecutor in support thereof states as follows. These are going to be all of the reasons why they would be requesting a special prosecutor. The following proceedings on February 23rd, 2023, a grand jury impaneled under cause number, yada, 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 returned indictments now prosecuted under this cause. That said, indictments and charging information were filed with this court on or about February 28th by White County Prosecuting Attorney Mark A. Delgado. That employed by the White County Prosecutor's Office is Deputy Prosecuting Attorney Christopher Phillips. That between the years of 2016 and 2019, Deputy Prosecuting Attorney Christopher Phillips and his wife, Attorney Christina Phillips, provided criminal defense representation in the following cases. And there's 1, 2, 3, 4, 5, 6, 7 cases that are listed here that Christopher Phillips or his wife participated in with the dealings of Garrett Kurtz. And if I am not mistaken, one of these or both of them, 2 of these are in relation to the F6 charge that was filed in Carroll County by Ashley Garth for the F6 strangulation, and then the violation of the protection order that was done on February 28th of 2019. So that based upon the overwhelming familiarity, the big word, between the defendant and attorney, Christopher Phillips, a perceived conflict of interest exists. So apparently they're trying to get a special prosecutor because they believe that there's a conflict of interest. Therefore, pursuant to Indiana Rule of Professional Conduct 1.10, said conflict of interest should be imputed to the White County Prosecutor's Office, disqualifying the office from continuing prosecution, necessitating the appointment of a special prosecutor. That IC code, yada, 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 provides that the trial court may appoint a special prosecutor if a person files a verified petition requesting the appointment of a special prosecutor, and the court, after notice is given to the prosecuting attorney and an evidentiary hearing is conducted at which the prosecuting attorney is given an opportunity to be heard, finds by clear and convincing evidence that the appointment is necessary to avoid an actual conflict of interest. Therefore, the defendant respectfully requests that a hearing be conducted on his verified petition. Wherefore, the defendant, by counsel, prays that this court grant his verified petition, appoint a special prosecutor, and for all other relief just and proper in the premises. Respectfully submitted, the law offices of Cody L. Spear, which is Garrett Kurtz's attorney. So he's asking for that prosecutor, the deputy prosecutor, to be removed in this case, simply because the prosecutor participated. I believe his wife was his defense attorney in several of his cases. So I do believe, if I remember correctly, this petition was actually denied by the court. I'll have to go back and check. I should have done that before I started recording, but that's why there was the petition for the special prosecutor in this case. Next, we're going to go through and read another document that was filed on April 3rd by Garrett Kurtz, and that is the motion for discovery and request for Rule 404 and 405 evidence. Comes now the defendant, Garrett K. Kurtz, by counsel, Cody L. Spear of the law offices of Cody L. Spear, PC, and moves the state of Indiana produce the following with regard to the above captioned cause of action to wit. Now, the reason I find this document fairly interesting is because there's a possibility that we could, if this case actually makes it to trial, which I'm hoping that it does, because otherwise I don't feel we'll ever have answers in Ray's case and who was actually present. I have a pretty good idea based on my research and some of my sources, but it's not 100% confirmed, so I don't want to speak on it. But I find it interesting. For those of you, I don't know if you ever watched or you followed the Alec Murdaugh trial, but there was a lot of 404 evidence, 404B evidence presented in that case. Basically, it's the possibility that the state could use prior bad acts against the defendant. So basically, this is a standard filing by the defense, basically requesting up front what information that they plan to use or what discovery they have to offer the defense in regards to those matters. So moving forward, one, the defense in their discovery request is asking for the names and last known addresses of persons whom the state of Indiana intends to call as witnesses, together with their written statements, recorded or taped statements, videotaped statements, memoranda containing substantially verbatim reports of their oral statements, and memoranda reporting or summarizing their oral statements. The names and last known addresses of the persons known by the state of Indiana to have knowledge pertinent to this cause of action, but who the state of Indiana does not intend to call as witnesses. So pretty much they want it all. Any and all written or recorded statements and the substance of any oral statements made by the accused by a co-defendant or by any other person, regardless of whether the state of Indiana intends to call such persons as a witness, and a list of witnesses and acknowledgement of such statements. 4. Any and all reports or statements of experts made in connection with particular case, including results of physical or mental examinations and of scientific test experiments or comparisons. Number 5, a statement as to any consideration the state of Indiana has given or intends to give any witness in exchange for his or her testimony. Now, I find that interesting, not that it's in this discovery, but in this particular case, based on my sources, it is Talitha Beckley who is possibly seeking something in exchange for her testimony or her knowledge. I don't know if I'm assuming she's trying to get some time off of her sentence, which that should not happen. And I'll go into that later because Talitha right now she's got a lot of explaining to do. Number 6, the names and the last known addresses of persons not intended to be called as the state of Indiana's witnesses, but who have been questioned or interviewed by the state of Indiana in preparation of this case, together with their relevant written or recorded statements, including memoranda, reporting, or summarizing their oral statements, and any record of prior criminal convictions known to the state of Indiana. A summary of any statement or conversation made by or engaged in by the defendant and overheard by any persons known to the state of Indiana, and a list of any witnesses who overheard such statements or conversations. Number 8, a statement as to whether any telephone calls, quote unquote telephone calls were made by the defendant following his or her arrest, and whether the calls were taped or overheard by any persons known to the state of Indiana. Well, isn't that interesting? Because how many of you heard the recorded phone calls from jail that he was allowed to continuously do on Open Secrets? If the call was taped, produce the tape recording, or if the conversation was overheard, then produce a memorandum of the conversation overheard, together with the names and addresses of all persons overhearing such conversation or conversations. Number 9, all books, papers, records, tapes, documents, photographs, videotapes, and other tangible objects and evidence which the state of Indiana may use in the prosecution of this matter, or which were obtained from or belonged to the defendant and co-defendant or any witness. Well, they've not ever named a co-defendant in this case. I don't know if the defense is anticipating a co-defendant. That would be interesting, but not unlikely under the circumstances of how all of this transpired. Number 10, a record of arrests and criminal convictions which may be used for impeachment of any witnesses who may be called by the state of Indiana, including but not limited to the defendant. Number 11, true copies of all written reports, notes, memorandum, maps, drawings, or diagrams, written, drawn, or otherwise prepared by the Stark County Sheriff's Department, any municipal police department, Indiana State Police Department, prosecuting attorney of Stark County, and any law enforcement agency or any private individual in connection with or pertaining to the investigation of the crime charged against the defendant. So I discussed this with Travis today about this Stark County reference in this discovery request, and what he explained to me was that there's possibly, when it says maps, let me see here. It says memorandum, notes, maps, drawings, or diagrams, written, drawn, or otherwise prepared by the Stark County Sheriff's Department. Travis has kind of explained that there could possibly have been a witness who was interviewed in this case in Stark County or is from Stark County. I have not been able to verify who that is. I have not been able to find any case of Garrett's from Stark County. I'm going to continue searching and see what I can dig up on that moving forward. Number 12, copy of the probable cause affidavit, transcript of oral evidence presented at probable cause hearing, or transcript of evidence presented to the grand jury in this matter, whichever is appropriate. A list of dates and times that the defendant appeared in any lineups, either in person or in a photo array. The names and addresses of persons who appeared in each of the lineups or photo arrays with the defendant, the names and addresses of any persons who viewed the lineups or photo arrays as alleged witnesses or victims, and what each of those persons stated regarding identification after viewing the lineups or photos. I wonder if one of Ray's neighbors or someone in that complex actually got to do a photo lineup to identify Kurtz as someone that he's seen coming and going from Ray's. I would really like to know the answer to that if anyone knows, if there's a family member who knows. There's a lot of holes here that I'm trying to fill in this case and Ashley's case, because they did only happen 16 days apart. And I don't believe that Nicole has gotten true justice in her case. And the further I go in this, the more confirmation I have of that. And there's a lot of things that I've been able to piece together that's going to fill a lot of gaps for a lot of people, and I hope that it's helpful at any sense. But the things that, if anyone out there has information that they would like to share or would like to reach out to me, you can email me at casebykcase10@gmail.com. I would be glad to communicate with you and share some information that I have, and maybe the last remaining pieces of these puzzles can get filled in. So finishing with this document, number 14, a statement as to whether or not the defendant, any vehicle in which he was a passenger, if appropriate, or his residence were searched following his arrest, either with or without a search warrant, and, if so, a statement of information contained and the items seized as a result of the search. In addition, if the search was made pursuant to a court-authorized search warrant, produce a copy of the search warrant together with the copy of the return. Well, when Garrett was charged, I highly doubt there was a search warrant on his residence at the time that he was charged in February of 2023 for Ray's murder, because his residence was the Pendleton prison in Indiana. So I highly doubt there was a search. However, I do know that the investigators from White County did, actually, I'm not even sure if it was White County, but I'm pretty sure that it was, showed up the weekend of the 23rd and 24th between Nicole Bowen's home and Ashley Garth's home, looking for Nicole and Garrett. And I believe it was at that time they had pieced together that Ray's death, there was something askew, and that it more than likely wasn't natural causes, as they so proclaimed, and failed to do an investigation on that poor man's death. Because, again, Ray's vehicle was pulled over in Tippecanoe County on March 14th with 3 occupants. We're going to get into who that third occupant was / or was not, because I don't believe that that person actually gave his true identity. And furthermore, at that time, Garrett Kurtz was living on Jason Palladino's property on Hodges Road. So I don't believe there was a search warrant issued at that time. Okay, number 15. A statement in writing by the prosecuting attorney of Stark County. There's that Stark County again. I'm going to have to do some more digging. Stark County, Indiana, that he has or has no information touching upon any matter of law or fact favorable to and or exculpatory of the defendant, and a written memorandum of such favorable or exculpatory information. Number 16. Any and all evidence in the possession or control of the state of Indiana or its agents which may be favorable to the defendant and material is the issue of guilt or punishment, or could reasonably weaken or affect any evidence proposed to be introduced against the defendant, or is relevant to the subject matter or the charge filed herein, or which in any manner may aid the defendant in the ascertainment of the truth. I'm going to have to get with Travis on that paragraph right there, because I think there might be some meat there that he might be better able to explain before I speak on that. Number 17, if there was an impoundment and a subsequent search of any vehicle, any and all written policies regarding inventory searches of impounded vehicle for the state agency which investigated the incident. Well, there was an impoundment, that's for sure. Number 18, any and all dispatch records of the state and or municipal agency in regards to this case. Number 19, pursuant to Rule 404 of the Indiana Rules of Evidence, You are requested to state the nature of any evidence of other crimes, wrongs, or acts of the defendant, which the state intends to offer for any purpose. State also under which exception in Rule 404B, the state will seek admissibility of the evidence. So that's a standard filing. But again, if any of you followed the Alec Murdaugh trial, the 404 and 404B evidence ruling, that's basically where the judge is going to rule whether or not the state is going to be allowed to bring in prior bad acts. Not necessarily as evidence, but basically to show his culpability or his behavior and character. So, there's a possibility whether Garrett was ever convicted or not in the strangulation of Ashley back in January of 2019. It did happen. It's on record. He was charged. He did violate that restraining order. And the manner in which he strangled her is very similar to what he did to Nicole. And the duct taping, the taping of the mouth, the hog tying, it's almost identical. And the details of what was done to Ray have not been released. And, as horrific as it is that the family would have to sit through a trial, I believe that might be the only way we're going to get true answers. I can tell you right now that my source, the storyline that's being told right now is absolutely a lie. And I believe the state knows it, and I believe that's why there is no plea deal on the table. I believe Garrett's attorney has really probably been fighting hard for him. I know that he was transferred originally to Newton County jail. I'm not sure why he was transferred there, but he was transferred there in order to be closer to his attorney for these negotiations. And subsequently, the jail ended up wanting him out. They didn't want him there. Apparently, they thought he was going to be a troublemaker. And shortly thereafter, they got him moved from the Newton County jail over to the White County jail. And he's been there now for, I believe, I think since August 31st, he's been in White County. And there's been some ongoing talks with the state, and I don't believe they're going to allow him to take a plea. There aren't any aggravating circumstances that have been included in the charge of murder, which that doesn't mean that they can't add those to these charges. It's not too late to add those, but the aggravating circumstances or the fact that they could end up charging him or filing he's as a habitual offender. And in the state of Indiana, he does meet, I believe he meets the qualifications to be charged as a habitual offender, and which means that in lieu of whatever plea he was to get, if he ever got one, they could add an additional 8 to 20 years separate to that. In addition to, I don't believe a habitual offender runs concurrent. It would be considered separate. So, but I think that Mark Delgado has enough evidence against Garrett that he's not going. I think right now Garrett's got two options, and that is plead guilty. And if he does that, he'll take the maximum sentence because I feel that they would have already offered a plea if it was going to be done by now. Maybe not, but what do I know? But doesn't seem like there is. And my source tells me that the talks are over and the judge is no longer going to extend his stay in White County. So look, if you want to follow his My Case status, I expect there to be a transport order put in. According to what I've been told, he's supposed to be transferred back to Pendleton on Tuesday of next week. So moving forward, number 20, pursuant to Rule 405 of the Indiana Rules of Evidence, you are requested to provide the undersigned with any and all relevant specific instances of conduct to be used by the state in cross-examination relative to evidence of character or a trait of character of any person which is material to any of the criminal charges in this case. The disclosure and production shall be made without regard to whether the evidence to be disclosed and produced is deemed admissible at the trial herein. All responses shall be reasonably supplemented, corrected, or amended when an additional and or different information and material becomes available. And that precludes the filing of discovery. And I do have some information here to read in the Indiana Code for 404, character evidence, crimes, or other acts, that I thought was important to discuss, since that may end up being a very relevant issue in this case if it does go to trial. Prohibited uses for the Rule 404, character evidence, crimes, or other acts. 1. Prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. Number 2, exceptions for a defendant or victim in a criminal case. The following exceptions apply in a criminal case. A, when a defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it, to rebut it, basically. Rebut, however you say it. B, subject to the limitations in Rule 412, a defendant may offer evidence of an alleged victim's pertinent trait. And if the evidence is admitted, the prosecutor may, 1, offer evidence to rebut it, 2, offer evidence of the defendant's same trait. C, in a homicide case, the prosecutor may offer evidence of the alleged victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. B, crimes, wrongs, and other acts. 1, prohibited uses. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person thanks buddy that a person on a particular occasion acted in accordance with the character. Notice, in a criminal case, this evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. On request by a defendant in a criminal case, the prosecutor must provide reasonable notice of the general nature of any such evidence that the prosecutor intends to offer at trial. B, to do so before trial or during trial if the court, for good cause, excuses lack of pre-trial notice. So I find those things interesting, that the evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So for any of you who are fully aware of the open secrets, which Garrett gave his interviews, he stated multiple times that it was an accident, or he has stated publicly that it was an accident. But I believe that Sarah from Open Secrets also made it very clear that he gave her a full confession confession, and that it included staging the scene, it included catfishing, and she was not going to release those audio recordings because she was going to withhold them for the prosecutor's office. So that may come in. I don't know. And I believe the next one that I have that I feel is relevant to this is the Rule 404, methods of proving character, reputation, or opinion. In all cases in which evidence of character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. Expert testimony on character or a trait of character is not admissible as circumstantial evidence of behavior. B. Specific instances of conduct. In cases in which character or a trait of character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of his conduct. So that's Rule 405. And when I can get a couple of people on here, Travis, for example, and possibly someone else that I know, to discuss the legal ramifications of what those rules can mean for Garrett's case, we'll discuss that. And I hope that you guys found this information a little bit insightful. Like I said, I didn't think that these documents had been floating around out there. And I think it's very relevant to Nicole's case and what transpired there, and how I've been doing not only research on Nicole, but also in Ray's case, because I feel that the two of them overlap in some way. And again, I apologize. It's taken me so long to get my lives up and going, but I don't like to fumble around and jumble around. And I know that's a heartache to listen to. And I like to get straight to the point, straight to the finish line, and get you guys the information that you logged on to hear or watch. So I do have all of the videos converted now, and I'm finishing up creating a timeline. And we are going to be going over the timeline of Nicole's last movements of that week that I've been able to verify and pin down. And again, I know that her family is not happy with me in my pursuit, but I do have some answers that I believe that they would probably like to hear in regards to her case, plus all of the interviews that I'm sure that they've never been able to sit and watch. But I do have the diagram of Jasmine Parker's trailer that I'm actually pretty happy with, that I've been able to put in like a digital format to go over the movements in that trailer that night and how the inside of the trailer was laid out. So that will be a part of the timeline as we get into the audio recordings and the interviews that I have, witnesses that I have interviewed. We'll get into those and where things stand with all of that. So if you find this information interesting and helpful, and you would like to participate more, especially in one of my live videos that's going to be up and coming, please like and subscribe and share. Simply, this is a brand new channel, and I don't know where this channel is going to go. I've always wanted to start a channel, like I've said before, and I got hooked on this case. I'm an advocate follower of Delphi, and this was one of the cases that I had followed right along with Delphi, and I've continued to follow this case. And I see a lot of um, I see a lot of similarities in Nicole and a little bit of my sister who or Nicole, yeah, my sister who passed away back in 2007. So anyway, please like, subscribe, leave a comment. If you have any information that you would like to share with me, casebycase10@gmail again is my email. I have created a new Facebook page for the Ashley Garth case discussion, and it's a private group. So if you're interested in joining there and having critical thinking and adult conversations, you don't have to agree with me. Let me say that again. You do not have to agree with me. But as adults, we can discuss and share information for a common goal. There's a lot of unanswered questions in Nicole's case. And I would love, for my own sanity, because this drives me crazy, not having all the answers, and I want all the answers. And wherever it leads is where it leads. So if you'd like to join, hey, please. Some family members of Ashley Garth are in there, and I think it's time that all of us need to, for the sake of finalizing the justice for Nicole and getting justice for Ray, that we have to be able to coexist to a certain degree and just be adults. And if you can't, I understand that as well. But again, I hope you enjoyed the reading of these documents. Is unfortunate that they have to exist in this manner, but I wanted to share them. And I will continue to share as I have more documents filed away. And I will continue to update you, but I had the time today to sit down and actually record. So yeah, I hope everybody enjoys your day. And I want to kick it over to, I know Frank Meister is going to be having a live later on tonight in regards to the Delphi case. He's going to be covering the new filing from Richard Allen's attorney, who has asked the judge to remove herself from the case, and he's going to be covering that. So I'm sure some of you will be over there, and I'll probably hop on and listen as well. So I will see you guys next time. Have a good day.